Good evening, Bahamas. You're tuned into NB12. Coming up tonight in news. This year's constitutional referendum postponed again. Why the opposition leader isn't surprised. The House Speaker flip-flops on a controversial contribution made by PLP MP Leslie Miller. The Attorney General hits out over late transcripts. Plus, the Miami Heat visit considered a slam dunk for sports tourism. We've got those stories and a whole lot more tonight. I'm Bonnie Toot, and NB12 starts now. Tonight, Bahamians were initially expected to vote in a constitutional referendum on gender equality issues in June of this year. Then it was postponed to November. Well, Prime Minister Perry Christie has postponed the major poll for a second time. He announced in Parliament this afternoon that a referendum will now be held next year.
That a referendum on the matter will be held throughout the nation not later than the end of June 2014. Following an ample period for public education and discussion, which will be led by the Constitutional Commission.
However, before questions of gender equality can be put to voters in a constitutional referendum next year, Prime Minister Christie pointed out that 6 separate items will have to be enshrined in amending bills. Those bills, he says, will be introduced in the House of Assembly before the end of this year. If 75% of parliamentarians vote in favor of them, Christie says he expects those bills to pass through both the House of Assembly and Senate by the end of February 2014. He says government will be looking at 2 areas of constitutional reform.
Firstly, the amendment of the citizenship provisions of the Constitution to achieve full equality between men and women with respect to the acquisition and transmission of Bahamian nationality. And secondly, the expansion of the definition of discrimination in Article 26 of the Constitution to include discrimination based on sex as a prohibited ground so that women would be able to enjoy the same level of protection from discrimination that men already enjoy.
He asserted that there must be a complete and definitive end to the second-class status of Bahamian women in relation to citizenship matters.
A Bahamian woman who is married to a non-Bahamian should have the same constitutional right that a Bahamian man has to pass a Bahamian citizenship to her child at birth, irrespective of whether the child is born abroad or in the Bahamas. Honorable members are aware that at present there is no such constitutional right. A Bahamian woman should have the same constitutional right that a Bahamian man has to obtain citizenship for her foreign spouse, but subject to amendments to the Bahamas Nationality Act to introduce further safeguards against citizenship claims that might be based on marriages of convenience.
Additionally, Christie says a Bahamian man who fathers a child with a foreign woman outside of marriage should have the same constitutional right that an unwed Bahamian woman has to pass citizenship to that child, subject to him proving paternity. As it stands, Christie says a child would have to take the citizenship of its foreign mother. He says these areas of constitutional reform are a matter of priority for the Bahamas.
Because of international treaty obligations that require our nation to end all forms of legal discrimination against women, in common, I would say, with virtually all of the modern civilized world. Even more fundamentally than that, however, it is simply unacceptable that there should be any further delay in bringing about the full equality of men and women in the Bahamian society of the 21st century.
However, the Prime Minister said it is important to point out that any amendment to Article 26 to outlaw gender discrimination could not be construed to legalize same-sex marriages.
A proviso should be added to make it clear that such an amendment to Article 26 would not overturn the long-established legal prohibition against same-sex marriages. Indeed, the Marriage Act already renders void any marriage that is not between two persons of the opposite sex.
These proposed changes are based on 73 recommendations presented by the Constitutional Commission on July 8th. Christie says it would not be sensible to advance all of the constitutional amendments at once. Therefore, he says next year's constitutional referendum would be limited to issues of gender equality. The Prime Minister noted that he also intends to appoint a new citizenship commission
to bring focused attention to the question of how children born in the Bahamas to non-Bahamian parents should be dealt with in relation to matters of citizenship and permanent residence. This, quite rightly, has been identified by the McQueenie Commission as a matter requiring urgent attention.
So what does opposition leader Dr. Hubert Minnis think of this latest postponement? He told NB12 it did not come as a surprise to him, asserting there was no way the Christie administration would have pulled off a successful referendum next month.
I'm not surprised because November, it just could not happen. You could not do the process. Most first world countries allow a certain time, be it months, for this to happen, and we just want to ensure that the same thing occur so that people know exactly what they're voting for.
What do you think of the new time frame, and will the official opposition support the referendum bills?
The bills are what we were bringing forth, so we cannot vote against something that we totally agree with.
As for efforts to eliminate gender equality, Minnis says the opposition supports them fully. However, he believes it is wrong that this issue is being put to voters by a party that encouraged those voters to reject it more than 10 years ago under the Ingram administration.
Tried to bring that forth, and the PLP voted against it. We're happy now that they see that there should be equality for both women and men, and they brought the bill forth. The point is, when it was brought forth by the F&M, the people had rejected it. The people had rejected it. And now bringing it forth again, this time the PLP bringing forth what we wanted to do, I think the people still needs to be educated properly on what they are voting for.
House Speaker Dr. Kendall Major did an about-face today, reversing his original decision to allow controversial remarks made by Tall Pines Member of Parliament Leslie Miller in August to remain on the record of the House of Assembly. Major today acknowledged that a private citizen was defamed. With a report, here's our Kendia Dames.
This issue has long faded from the headlines. The controversy that had surrounded it is no longer fueling public discussion. And today, the House Speaker made a ruling that had not been widely anticipated.
On August 12th, Tall Pines MP Leslie Miller named Dion Bowe in relation to the 2002 murder of his son, Mario Miller. The House Speaker did not stop Miller from speaking to that issue, and in fact, he later defended Miller's right as an MP to say what he said. Major said at the time that no House rule blocked a member from attacking a private citizen on the floor of the House. Here's what the Speaker told NB12 back on August 13th.
Because of the fact that he is within the rules, which clearly states that a member has the privilege of free speech, and as long as he stays within the rules of free speech as it pertains to the rules of the House, then he is within his rights as a member of Parliament to call a name of an individual, although understandably it may be astonishing to the public.
But today, the House Speaker expressed a change of heart, while noting that the damage has already been done.
I was disappointed that a private citizen with no recourse to justice was defamed. And as a result of this occurrence, and upon reflection, I feel a moral sense of duty to make amends, with notwithstanding the fact that the damage was done. Consequently, I do hereby order that the statement made by the Honourable Member for Tall Pines with respect to the highlighting of the name of the individual be expunged from the records of this House.
Back in August, there was outrage in some quarters that Miller had named a private citizen. That man, Dion Bowe, told us at the time that he was appalled.
As far as my response to this, I feel that it's completely absurd. It's ludicrous that Mr. Miller would even come up with accusations to defame my character in such a way.
But the speaker at the time frowned on any suggestion that the comments be withdrawn. After finally expunging them today, he gave the media a warning on publishing the comments.
When the chair orders an expungement, it not only speaks to the prohibition of the expunged words being cited in the press, it also removes the offending words from the official records. If the press chooses to publish the words after they have been ordered expunged, this act will be regarded as an affront to the authority of the chair. Additionally, it means that the press loses its privilege and protection of freedom of speech by reporting something in violation of the House rules. The press would therefore be subject itself to libel and defamatory laws and penalties from the chair.
But because Major had initially allowed those controversial comments to remain on the record of the House, they were widely published by the media. Besides all that, they were carried live by the parliamentary channel and heard by many who were watching the August 12 proceedings of the House. It is in fact impossible to take any of that back.
Major noted today that the House rules and procedures have not yet caught up to technological realities. He pointed out that this is an issue that many parliaments are grappling with. Reporting for NB12, I'm Candia Dames.
The proposed Correctional Services Bill was tabled in the House of Assembly today. National Security Minister Dr. Bernard Nottage says it seeks to ensure inmates at Her Majesty's Prison are engaged in the most modern methods of rehabilitation to ready them for reintegration into society. The bill will repeal the existing Prisons Act and offer more comprehensive, modernized legislation that is expected to be more in line with international standards. The new legislation will also see Her Majesty's Prison's name changed.
It will provide for the facilities for such persons, that is, correctional and holding facilities, and in particular, provide for the continuation of Her Majesty's Prison, which will be known as the Bahamas Department of Correctional Services once the bill is enacted. It will also provide for the declaration of suitable places to be a correctional facility. It deals with the administration and functions of the Department of Correctional Services, provides for the appointment of a commissioner, deputy and assistant commissioners, such appointments to be made by the Prime Minister, acting on the advice of the Minister.
While the legislation would provide the framework for a Correctional Services Review Board to act as the watchdog of the department, it will also replace the current visiting committee and have access to any inmate or part of the facility. The review board will also be empowered to establish and implement regulations with the approval of the National Security Minister. The new bill also provides for inmate work release accounts.
Clause 43 of the bill seeks to grant the review board the power to authorize an inmate who has completed at least 1/3 of his sentence and has less than 2 years remaining day release to engage in work which he is directed to carry out, to receive instruction or training in a program established under the bill at an accredited institution approved by the Commissioner, and to participate in church services or programs to promote the success of reintegration of the inmate into society.
Amid continued industrial action by court reporters, Attorney General Alison Maynard Gibson is making it clear her main concern is late transcripts provided by those workers. Routinely, she says court transcripts are still not being delivered on time, causing pain and inefficiencies in our court system.
Matters are being adjourned, causing several things to happen, including litigants to experience pain, if I could put it that way, in the criminal courts, experiencing inefficiency and high cost in the civil courts, and also causing our country to have a very bad rating in terms of efficiency. You'll see the efficiency rating, and we're at number 87.
Her comments come after the majority of stenographers called in sick for at least 3 days in protest of several issues, including the lack of a career path, late salary payments, insufficient equipment, and, well, criticism over late transcripts. She refused to address payment arrangements but said this.
Theophilus' company, called LET, is an independent contractor, and I really don't wish to get into her administrative arrangements with her staff. I just simply repeat that we are insisting that transcripts be delivered on time so that litigants before the courts can have their matters disposed of quickly on the civil side, and that on the criminal side, persons who wish to swiftly prove their innocence and victims who want their matters swiftly dealt with, those matters will be dealt with because the transcripts will be in place.
The AG says government is ensuring that an internationally accepted court reporting unit is implemented. Despite reports that operations at the South Street Magistrates Court complex were crippled by stenographers' actions, Maynard Gibson insisted that they continue to operate. She insisted judges took notes of court proceedings.
The Supreme Court and the Court of Appeal have not been affected by this, and the magistrates' courts have continued to operate. I just want to point out that in other jurisdictions around the world, I've just come back with the Chief Justice and others from looking at the courts in the UK. We visited the Westminster Magistrates' Courts, and court reporters don't sit in those courts. I want to thank the magistrates for sitting and continuing to serve the public well. The judges, that's what happens in other jurisdictions, and some of us are old enough to remember when the judges would take their notes, and in fact, as a matter of law, the judges' notes are also the official record.